Hello, this is Schlissel, and today I'm going to talk to you about a mortgage lender who was penalized for failure to comply with notice requirements. Judge Dollinger, who was sitting in Rochester, New York, recently ruled that a mortgage lender who didn't comply with consumer-friendly notice requirements under New York state law should be given a second chance to comply. However, he also held they were permanently enjoined from imposing any interests, fees, costs, or legal expenses on the mortgage holder from 90 days before the filing of the complaint until the bank complied with the New York State notice requirements. New York has a law called the Foreclosure Prevention, Tenant Protection, and Property Management Act. The Foreclosure Prevention, Tenant Protection, and Property Management Act, which was passed in 2009, requires a lender to give a homeowner notice prior to the house being foreclosed on. In the case before Judge Dollinger, City Mortgage failed to do this. Judge Dollinger was concerned that if the case was dismissed, Citibank would get a second chance to comply with the statute's notice requirements. However, the judge noted in his decision the bank's failure to comply with the notice requirements in their first attempt. If they were successful in a second attempt, the borrower would be worse off because they would be responsible for the entire amount of the unpaid debt, including the portion of the interest, penalties, and attorney's fees which accrued on the debt during the period of time between Citibank's first chance at complying with the statute and their second chance. Judge Dollinger wrote in his decision, the borrower is worse off because the amount of the debt has been increased during the 2-year period in which the foreclosure action has been pending, making a recasting of the mortgage more costly, if not prohibitively so. To deal with this, Judge Dollinger entered an order permanently enjoining the bank from imposing any interest, fees, legal expenses, or penalties on the borrower from 90 days before the filing of the complaint until such time as they have fully complied with the statute. New York Real Property Actions and Proceeding Law, Section 1304, requires a creditor to notify a borrower by registered or certified mail, as well as by first-class mail, offering assistance on how to avoid foreclosure. City Mortgage had failed to comply with this section of the Real Property Actions and Proceedings Law. In the case before Judge Dollinger, he stated there was no sworn statement from any bank official regarding the mailing. Judge Dollinger, based on the bank's failure to provide the sworn statement regarding mailing, could have dismissed the foreclosure lawsuit. He refused to do so because he stated if he dismissed it, the bank will escape the consequences of its failure to follow the law. Judge Dollinger went on to state, when and if the bank complies with this statute, it can collect any principal payments due at any time under the note and mortgage. Judge Dollinger's ruling, however, denied the bank the ability to collect interest, fees, costs, and attorney's fees during the period of time the bank was in non-compliance with these statutes. In conclusion, this was a victory for mortgages, although in my personal opinion, only a very small victory. Thank you for watching me today. Schlissel, foreclosure lawyer, signing off.